have our seats. Reference number 1, year 2025, a matter before the Jumuiya Court of Justice. The applicants on this matter are the Jumuiya Law Society, rallied together with 31 other people against the respondents who paid the Attorney General of the Republic of Glory, together with the Secretary General of the Jumuiya Community. The brief facts of this case is the virtue that people, referred to as the Namash people, that coexist within the Kaluma region, of which is the subject matter in the matter laid before this honorable court this day, were arrested because of having arms. Pursuant to the facts, we will see that these people were armed in such a manner because of the insecurity that lies in the area with which they reside in. The matters laid before this honorable tribunal is whether, one, the matter brought before them has the admissibility to be heard, or rather to be brought before them, and whether this court does have jurisdiction on the matter that will be raised here. The second issue that will be determined by this honorable judges is the virtue on whether there was a violation of the treaty that is enshrined in the treaty that establishes the Jumuiya community when it came to the unlawful, or rather to the court-martialing of these people from the Republic of Kaluma with regards to their carrying of arms. I will welcome the voters to be able to make their submissions in the order of the applicants and the defendants. Each will have 4 minutes to make their submissions, and thereafter the judges will make their decision. Thank you.
I'll be handling the first issue on whether this court has the jurisdiction and whether the issues before this court are admissible. And my co-counsel will be handling the issue on whether the arraignment and the summary convictions of the civilians in the Glory court-martial was violated the treaty. On the first issue, the applicant's position is that this court has the jurisdiction and the issues presented before this court are admissible. And I'm guided by 2 limbs of arguments. First is that jurisdiction flows from the treaty, and the second issue, on the second limb, is that the applicant has the local standard to present before this honorable court. If it pleases my lordship, I'd like to begin. Thank you, much obliged. On the first limb of argument, on whether the court has jurisdiction and the issues before this court are admissible, we the applicants say that this court has the jurisdiction and the issues before it are admissible. Firstly, we contend that jurisdiction flows from the treaty, and we are guided by Article 27 of the treaty establishing the Jumuiya community, parimateria for the East African community, that's the law we'll be using. Article 27 provides that any matter pertaining to the interpretation and the application of this treaty can be brought forth before this honorable court. My lordship, we the applicants present this case before this honorable court pursuant to the violations by the respondents, particularly in Article 6, paragraph D, and Article 7, paragraph 2, which these mainly are the core principles that brought about the formation of this Jumuiya. Key of these principles are the principle of rule of law and the principle of good neighborliness, of which we are able to see that in paragraph 18 of the fact pattern, the respondent, which is the Republic of Glory, did not adhere to such. They went ahead and violated the principle of good neighborliness, of which the article in this treaty advocates for. My second limb of argument on whether the applicant have the local standard to present before this honorable court, I am guided by the case of Professor Anyang' Nyong'o versus the Attorney General of Kenya, in which this very court established that any person, a legal person, a natural person, a political party, or a civil society can go to bring forth a matter before this honorable court. It therefore suffices to say that the applicant has the local standard necessary to present before this honorable court. Again, on Article 30 of the treaty establishing the Jumuiya, clearly states that this matter suffices to be brought before this honorable court because it states, as I quote, it permits any legal or natural person resident in a member state to bring a reference before this honorable court. As we are all aware, the JLS which is the party bringing forth this matter, is a regional bar body that comprises of member states from the countries making up the Jumuiya. My Lordship, on the issue of the time bar, I refer this Honorable Court to Article 30, Paragraph 2 of the treaty, which clearly references that for us to bring a reference before this Honorable Court, it should be within the 2-month bar period that has been put forth by the treaty. And all this has been adhered to by the applicants. I'd like to usher my co-counsel to address on the remaining issue. Thank you, my Lordship. Thank you.
Much obliged. May it please this Honorable Court. My Lordship, my name is Maina Barak, appearing on behalf of the applicants, that is the Jumuiya Law Society, as well as 31 other applicants. If it pleases this Honorable Court, I would like to proceed and begin my submissions. I'll be dispensing on the merits of the second issue, and I have just 4 limbs of my argument. First, that the denial of human rights by the commercial court, or rather by the court martials, violated the core principles of the ESC, or rather, because as my earlier respondent, or rather my earlier applicant stated, we are here pari materia because this is an analog of the ESC laws. So we will be relying on the ESC community treaty. First of all, Article 6, paragraph B, and as well as Article 7, paragraph 2 states that the principles such as rule of law should never be an issue before this Honorable Court. Therefore, we have the jurisdiction to bring forth any issue relating to the interpretation and the violations of principles such as rule of law, fair trial, and as well as good governance and people-centeredness. By violating these principles, they actually tried civilians in the court martial without, first of all, a person to Article 15 presenting person to paragraph 15, they did not present, or rather they did not accord the applicant legal counsel. Furthermore, they did not practice public hearing, therefore they made these decisions summarily. They did not consider the applicant's side. Furthermore, we bring these issues because our issues were dismissed by the Court of Appeal when we appealed. They were quashed, rather they were dismissed by the Court of Appeal. Therefore, that's why we came to this to come to this avenue. Furthermore, we have the DCOTS principles that were established by United Nations Special Rapporteur in 2006, stating that, first of all, we have the right to counsel, as I'm winding up, Your Excellencies. First of all, we have the right to counsel, we have the right to public hearing, as well as we have the right to appeal. We were never accorded these principles by the respondents. Therefore, with that, we used to state our prayers, that is, to quash the decisions and to order for the release of the imprisonment, or rather for the imprisoners, those who are prisoned, and also to convict, or rather to issue an interim order to retry in a civilian court jurisdiction, my Lordship. With that, I wish to cede the floor back to the Honorable Court.
Honorable Judges, my name is Daniel Bishure, counsel on the behalf of the respondents. I'll be here to tackle the first issue, that is whether this court is seized of the requisite jurisdiction to deal with this case. It is our contention as the respondents that this court lacks the requisite jurisdiction to adjudicate on the matters presented before it. We make reference to Article 27 and Article 2, which states that the extension to deal with human rights violation has not yet been, will be in place in the ESCJ once a protocol has been put in place. It is my contention that the ESCJ has not, the East African community has not yet put in place a protocol detailing how the East African Court of Justice should be seized of the jurisdiction to deal with humanitarian obligations. We use the case of the James Katabazi and versus the Secretary General of the EAC and one another, in which the East African Court of Justice asked the question whether this court has the jurisdiction to deal with the same, and emphatically stated no, it does not have the jurisdiction. Secondly, I will use the ambit of the reference being time barred as stated in Article 30 sub Article 2 of the ESC Treaty, which states that proceedings instituted within 2 months of a partner state's challenge or impound actions will be valid. This means that any action or any challenge brought before the East African Court of Justice after 2 months will be invalid before the court. Similarly, in the AG of Uganda versus Omar Awad and 6 others case, the court upheld the appellant's challenge to the turning down of the limitation of time argument used by the applicants. It stated, in fact, and referencing also the case of the Independent Medical Legal Unit versus the Attorney General of the Republic of Kenya, that the importance of this article, that is Article 2, that is Article 2, is to preserve the principle of certainty. Now, this case has been placed on the challenges of the actions that occurred on the 17th of March 2023. However, you will notice that the case was instituted before this court on the 23rd of July 2023. It is in those few remarks that I beg the court to find that this court is not seized of any of the requisite jurisdiction to deal with the case and the matters within it. Thank you, and I cede the floor to my co-counsel.
Good afternoon. Honorable members of the bench and all dignitaries here. My name is Francis Katitu, second counsel for the respondent, and I'll be dealing with issue 2. In the re-establishment of the Jumuiya community, certain principles were embedded in the treaty to ensure its survival. Key among them have been mentioned here, particularly the fundamental principles under Article 6 and Article 7 of the treaty. They include mutual sovereignty principle and the principles that have been enunciated by the petitioners. Key among them, however, and especially pertaining to the principle of sovereignty, was that member states still retained the security, the right to protect their citizens, so that when they were enacting certain provisions of the East African Community Treaty, they could put a stop to it, or rather delay in enacting them due to the reasons of security. The instant case talks about that, and the question is whether the arraignment of civilians in the military court in glory was lawful under the treaty of the establishment of the East African Community. We argue as follows: military justice generally and military courts generally are designed to deal with the military. In most cases, civilians are not supposed to go there. However, pursuant to the DeCox principles and other principles, the Yale-Durham principles, and even jurisprudence from around the world, particularly the United States of America and Pakistan, Nepal, and other countries, therein it is stated that in exceptional circumstances, civilians can be tried in military courts. In the instant case, as has been argued by the first respondent counsel, the people of Namash entered into glory. With them, they carried firearms. Pursuant to the Glory Defense Act, that was illegal. And the punishment, or rather the procedure that was supposed to be followed, if one is found with a firearm in the nation of glory, was that they will be taken to the court-martial. And that is a practice that has been going on since 2001, as pursuant to the fact sheet. Therefore, when the Namash people were caught with the firearms, they were taken to the court-martial. The pertaining reasons to that was for the protection, for the security, and for the safety of the people of glory. With that, I have to submit. Thank you.